thank you everyone, as I said, for joining us this evening. This is our 7th lecture of our Bitesize Animal Law Series. Just to let you all know, next week we will not be hosting our 8th webinar. We'll be attending Advocates for Animals webinar on effective animal advocacy. So you can all join us again on July the 1st. That will be not next Wednesday, but the following Wednesday at 7 p.m. So thank you very much for those of you who this may be your first webinar, or maybe you've been attending since the beginning. If you have missed any, it's no worry, because we will be posting them to our YouTube channel once the series is over. And before I introduce our speaker for this evening, I just want to let you all know how you can participate in the Q&A. I know a lot of you already know this very well, but for those who might be joining us tonight for the first time, in order to participate, you will see a little Q&A icon at the bottom of your screen. So make sure that you enter your question in the Q&A and not the chat box. And if you do want to submit anonymously, you can just select Submit Anonymously, and we won't be able to see your name before you submit your question. And lastly, if you do see a question that you equally would like to have answered, you can select to vote it up, and Libby and I will be able to see which questions have gained more popularity to answer. Okay. So tonight we are welcoming Libby Anderson from One Kind, and Libby will be discussing current issues and challenges in wildlife protection. And Libby is the policy advisor for One Kind, which is formerly Advocates for Animals. And she was previously the charity's policy director. Over the past 20 years, Libby has worked to influence Scottish legislation, and she's worked with relevant animal welfare, including hunting with dogs, the regulation of snaring, the protection of seals, general licenses for taking and killing of wild birds, and the use of wild animals in traveling circuses. So Libby is also involved in supporting campaigns on wild animal welfare issues, such as a ban on snares and other traps, the culling of mountain hares, and the use of glue traps as well. She is the secretary of the Wild Animal Welfare Committee, which is WAWC, which she helped to found in 2014. So let's give Libby a warm, silent welcome. Thank you, Libby.
Thank you, Tiffany, and good evening, everybody. Thank you also to ALAW for inviting me to make the presentation in this series, which I've been finding absolutely fascinating so far. So as you've just heard, my background is in advocacy rather than law. I'm a lay observer and not a legal expert, but it's fair to say that over the last years, I've done quite a lot of observation and a little bit of interference. So I hope I will have something of interest to say about animal welfare law as it regards wildlife. Now, I want to give you a little bit of hot news, which is not even completely up to date because I'm waiting to hear for a little bit more. But there is legislation passing through the Scottish Parliament today. It's at the stage of amendments, and then there'll be a plenary debate. But so far, on the wildlife side, we've seen an amendment accepted that would extend vicarious liability, so for the use of traps and snares, so that employers or landowners whose employees, gamekeepers, agents commit a relevant offence, they would become liable under the new vicarious liability provisions. That's an interesting new development. And we've also got 2 new amendments which effectively bring a ban on seal shooting in Scotland. And the one I'm hoping one of my colleagues will send me a text about, but you who are watching will have the possibility of looking at this sooner than I will, is to find out whether increased protection, full protection for mountain hares will be accepted by the Scottish Parliament today. So that's the breaking news. And meanwhile, back to the script. So what I want to do in the planned part of the presentation is to look at the imbalance between the protection that the law provides for domestic animals, to use that bit of shorthand, and the welfare of free-living wild animals. After that, we'll look at a bit of the chronology, which explains how we got where we are today. And then we'll consider the growing fragmentation in the way that the law treats wild animals in different parts of the UK. So like previous speakers, I think the starting point for me has to be the question of animal sentience. It's the reason why we have regard to their welfare. If you've been following this series, you remember that a couple of weeks ago, Mike Radford spoke about the Animal Welfare Acts, and he highlighted that these acts recognize the sentience of the animals covered. Now, they don't do that in explicit terms on the face of the statutes, but implicitly they do so. They reflect animals' capacity for experiencing poor welfare, including mental suffering, and they place a duty on people who are responsible for these animals to ensure and provide for their needs. And then last week, Steve McCulloch highlighted the importance of adequately defining sentience and acknowledging that animals experience positive states as well as negative welfare and suffer. Well, that's accepted now for domestic animals, and that's why the law is providing good welfare as much as it can, as well as prohibiting unnecessary suffering. Well, do we have anything like that for wild animals? Clearly, we don't under current legislation. Wildlife legislation sees animals in terms of populations rather than sentient individuals. This is a legacy of its roots in species conservation, and we'll see that a little bit more shortly. But meanwhile, I've put up on this first slide a summary of the current domestic statutes, the fact that they recognize sentience and promote welfare. They're limited in their scope. The different approach of wildlife legislation, but also I wanted to mention that language in legislation is so important, and our current legislation is still imbued with these very outdated words, laden with values, negative values very often, words such as pest, vermin, manage, control. And I think it's arguable that these legitimate outdated attitudes to animals. And this basic contradiction means that a fox and a dog are incredibly similar in terms of their sentience, but you can treat a fox in a manner that would be entirely illegal if you inflicted that treatment on a dog. So the next few slides, next 4 slides, contain images of animal suffering. I wanted to warn you about that. I think it's important for us all to have an idea of how legal actions impact on sentient individuals. I could have put in some slides that were even more distressing, but I just am warning you about that. And if you want to look away, well, feel free to do that, of course. We've got limited time available, and so for the next half an hour, I'm really focusing on wildlife control commonly carried out in the countryside. So I'm going to start with some traps which are very commonly used on sporting estates and farms. You can see on the left, there's a snare there. It's a wire noose, very commonly set to trap mainly foxes, rabbits, and hares. The idea of a snare is that it will catch the intended animal by the neck and hold it there until the operator comes to kill it. Legally, this can be a period of up to 24 hours. As you can see, the animal in the middle is a badger, a protected species, and this indicates the fact that snares are highly indiscriminate, not only in the non-target animals that they capture, but also in the age and stage of the animals that they catch. And also, they are so crude that they can catch the animal around the wrong part of the body. So not round the neck, not like a dog on the lead, as I've heard gamekeepers describe it, but around the abdomen, under the front leg, and this can cause very serious injury. In addition, of course, the animals struggle. And the more they struggle, the more the noose tightens, it can become tangled, and their suffering is increased. However, snares are legal. Legislation varies. I'm going to talk more about that a little bit later on, but they are legal. And the other thing in this slide is the illustration of a stink pit. A lot of people know about snares, but they don't know about stink pits. Really, it's a pile of carcasses, very often of animals that have been snared or shot. They're dumped in the open to decompose. Snares are set round the stink pits. The smell attracts in predators, especially foxes, and then they can be trapped in the surrounding snares. Now, there is a debate as to whether stink pits are legal. I've seen some very involved arguments about waste disposal regulations and licensing. Not very sure what the legal position is, but government, as you can see, the Scottish government has advised us that they are legal as long as they don't use livestock, because that's prohibited under the animal byproducts regulations. Right, so now we're going to move on to spring traps. And again, these are used very commonly on sporting estates. They're regulated under spring traps approval orders, which are made under the Pest Act or equivalent legislation in other parts of the UK. And the orders specify by name the brands of traps that may be used. They set conditions about placing them in a cage or natural tunnel so that a non-target capture should not occur. They're traps for killing. Snares that we saw previously are restraining traps, and therefore they have to be inspected at a regular interval, 24 hours. A killing trap doesn't have that requirement placed on it, so there's no inspection requirement for kill traps, because the idea is that the animal will be killed instantly, or at least rendered irreversibly unconscious instantly. That is the idea. But as you can see, they can catch non-target animals, or they can catch the animal by the wrong part of the body, and therefore it doesn't die quickly. These traps are antiquated and many people feel they shouldn't be allowed, but actually there are thousands and thousands of them used in the countryside. Now, the UK is bound by the terms of the Agreement on International Humane Trapping Standards. That's a treaty that was originally brought in to protect fur-bearing animals in countries where the leg hold trap was used. And as the years have gone by, eventually some implementation was brought in the UK in the shape of the Humane Trapping Standards regulations. It's only stoats that are fur bearers as designated under the AIHTS treaty. And the way it's been approached is that there are new orders for the use of traps to catch stoats. There are new general licenses issued under the Wildlife and Countryside Act permitting people to use these specified traps. But of course, and one of those common traps is one called a fen trap, which is perhaps the original popular spring trap. And it would now be illegal to use a fen trap for, let's say, for a stoat, but you could still use it for a weasel. And of course, again, they tend to be indiscriminate. Now, another kind of spring trap is the much more common mouse trap. You'll have seen these in use. These are exempted from the spring traps approval orders. There must be millions of them in use, and they're very commonly bought and sold in the UK. So they have a blanket exemption. There is considerable concern about the humaneness of all spring traps, including these ones for the moles, rats, and mice. And experts such as Dr. Sandra Baker has carried out a lot of research into matters such as impact momentum, the potential, the effectiveness of the trap in actually killing the animal instantly, which is the benchmark for humane killing. There is no regulation to provide for that, and the researchers have suggested there should be an approval scheme. We might mention that a little bit more later. But the other kind of traps very commonly used for rats and mice are the glue traps. These are used by pest controllers. They are on sale to the public. You can buy them on eBay and Amazon. But the way they work is by spreading a non-setting adhesive. The animal becomes caught on it. It can't release itself. There is no regulation for these traps other than under the Animal Welfare Act. Because once the operator has caught the animal is thought to be responsible for its welfare. It has the duty of care, and therefore he should inspect the trap regularly. But they are not regulated specifically otherwise, and they're known to cause immense suffering. I've even seen people who sell these traps saying only use them in the very last resort. Well, there's been a lot of political concern about that, petitions to Westminster, the Humane Society International Unstuck campaign, and a petition in the Scottish Parliament as well. But you can see just down on the left of this slide, the response to the UK petition was that the government has no intention to ban the use of glue traps. Moving on now to traps that are used for wild birds. So wild birds are all protected under the Wildlife and Countryside Act. That means in general, all taking or killing is prohibited unless the operator has a license under Section 16 of the Wildlife and Countryside Act. Some licensing is specific and the operator would have to apply individually for their license, but the demand to trap certain wild birds, in particular corvids, is so high, they're considered to be pests to certain interests, that these are covered by general licenses. There's no individual license. The licenses are simply posted on the relevant agency websites, and the operators simply have to comply with them. And they do have conditions on them. Some of these conditions are intended to secure the welfare of the birds that are in them. One in the middle on the bottom, that's one called a larsen trap. That is permitted under the general licenses. The one on the left is usually called a crow cage trap. It's a good deal bigger and would catch more birds in it. Both of them work by the use of a decoy bird. And the decoy bird is captured, placed in the cage, and therefore other birds, highly territorial, come to see what's going on, and they in turn enter the trap and are unable to get out. So you have birds that are basically not wanting to be in close proximity to one another, forced to remain there for a long time in stressful conditions. It's necessary to provide food and shelter and a perch for these animals, for these birds. And that is only required for the decoy bird. The decoy bird could be in the trap for a long time. The ones that are newly captured should only be there for 24 hours, and there's no provision requirement for the food or shelter or perch for them. But as you can see, this is very rudimentary. The birds can be exposed to very severe conditions in addition to the general stress and suffering. So all of these methods that I've described just now are legal. In my opinion, that of many others, they cannot operate without causing suffering, but they're legal. Now I'm just going to, it's really impossible to say how many animals and birds are affected by this. I'll just give you a snapshot. So this is a Gamekeepers logbook from one single year on a pheasant shoot and grouse estate in the Scottish borders. And this came to light because there was a cruelty case a year or so ago. And the gamekeeper had very diligently recorded the number of foxes, cats, rats, stoats, weasels, etc. that he had killed on the estate. So you can see 103 stoats, 622 rooks, even 32 cats. This is possibly a cultural approach, and probably out with the scope of this talk, but the bottom line is we see over 1,000 animals and birds were killed on one single sporting estate. You only have to multiply that by the hundreds of sporting estates and farms across the UK. And then consider also those rats and mice that I mentioned that are caught in domestic circumstances. And your guess is as good as mine as to the number, but it's many hundreds of thousands. That's a question of scale, but of course they are sentient individuals. Now, I think if we wonder why their welfare is not addressed so well, it might be useful to look at how we got where we are today with our wildlife legislation. Now, this slide may look like a design for a new tartan, but in fact, it's my attempt to show in a reasonably accessible manner the chronology and the varying directions of the main legislation. And I promise we're not going to go through it line by line. It's simply to show that it all started really with the Council of Europe, the Convention on the Conservation of European Wildlife and Habitats, better known as the Berne Convention. That was the first international treaty to address the protection of both species and habitats. And it placed legal obligations on the contracting parties. It protected over 500 wild plants and over 1,000 species of wild animals, ratified by the UK government in 1982. And originally those obligations were transposed by the Wildlife and Countryside Act, which is well known to everyone, I'm sure, and remains our primary wildlife legislation. And that act also transposed the Wild Birds Directive from the EU. Moving on, in 1992, the EU Habitats Directive introduced rules that in many ways were stricter, although they had a tighter geographical spread, confined obviously to the European Union. But again, it was protection of species and habitats. Welfare wasn't in there. In fact, this species and habitat protection is also concerned to permit and regulate the exploitation of wild creatures, for example, through hunting. And it also is intended to secure the destruction of creatures that are viewed as pests. So a specific function of wildlife legislation is to require the killing of certain wild animals. So invasive species or species deemed to be damaging would be among those. Now that's quite hard to accept, but it could be argued that by regulating hunting and prescribing killing methods, it actually does have a function in preventing a free-for-all where animals would be killed, for example, at any time of year. Whereas by regulating these practices, you can provide for close seasons and animals are protected during their breeding times. Another thing to remember is that conservation is a good thing, but there are conservation practices that are inimical to animal welfare where the individual is concerned. And examples of that would be the tagging of animals for identification, certain reintroductions have got welfare implications, or translocations of individuals. These all have an effect on the welfare of the individual. And then finally, and this is the excuse for the tartan slide, we have to add to this jumble the fact that since devolution in 1999, we've seen increasing divergence between the UK administrations. The Wildlife and Countryside Act and the regulations have been modified at different paces in different countries. So in Scotland, as of around 8 o'clock tonight, the Wildlife and Countryside Act will have been through 3 rounds of amendments by primary legislation. Still very much focused on species and populations, but you can see differences now opening up as regards welfare. Well, there's more. So this is a snapshot of the legislation in England alone, because while in Scotland, we've just been getting on with it to some extent and amending legislation in areas that seemed appropriate. The approach taken in England, where it was accepted that the law is a patchwork, this is the word used by the Law Commission review, it's accepted that it needs review and consolidation, but we haven't really seen much progress yet. So the Law Commission was actually asked by DEFRA in 2011 to review some of the legislation. I think there's about 12 pieces of legislation in that list, and it reported in November 2015. It recommended a single statute to replace this patchwork of legislation. It wanted to keep the protections for wild animals, birds and plants, but to make a simpler statutory procedure for amending the schedules, the lists of different categories. They wanted a 5-yearly requirement to review these lists. They wanted to introduce civil sanctions such as fines and bans rather than depending so much on the criminal law. And they recommended increasing the penalty for the most serious wildlife crimes from 6 months to 2 years in prison. Unfortunately, this has not proceeded, and you can see the Law Commission's very dry account of what happened. The UK, in this case talking about England, the UK and Welsh government have no intention of implementing these recommendations, and the reason given was the implications of Brexit. So that's, as far as I know, be interested to hear from people watching this, but as far as I know, that is where we've got to in England so far. So let's recap a little bit before we move on. So we've got the domestic animal welfare legislation, which is coherent and up to date. I haven't really mentioned the welfare of farmed animals, but here again, the regulations are very much based on EU legislation, and they also recognise the sentience of animals. Wildlife legislation takes this different approach, conservation and control. Mentioned already that some activities can be inimical to the welfare of the individual animals, and there is this complication of a huge number of statutes and amendments that have opened up. And then if we're thinking about obstacles or complications to making progress and achieving that consolidated legislation, which does appear desirable, there are, first of all, certain categories of people who resist change. Many members of the public dislike sports that involve shooting and hunting, but there's no denying that they're undertaken by influential people and possibly people who have the capacity to offer employment and claim a contribution to their local economies. So there is resistance to amending these. The next thing on that side is it's controversial. I'll speak about that a little more in a moment. And then we have this fragmentation arising due to devolution. Well, if we want to talk about controversy, let's think about fox hunting. Scotland was the first country in the UK to introduce a ban on fox hunting. Now we call it a partial ban on fox hunting. It came through in 2002 after a long and extremely painful process in the Scottish Parliament. I've just put up one little quote from a member of the committee. It was actually Richard Lochhead, who did go on to be the Minister for Rural Affairs and the Environment. But as a committee member, he described this bill as a nightmare. He described trench warfare and the committee fighting itself to a standstill on some issues. Well, that was in Scotland. Not exactly plain sailing in England either. The legislation that went through Westminster following that and following the long drawn out, very detailed process of the Burns inquiry, that again sounded a bit like trench warfare. And eventually it was only passed using the Parliament Act, which is what has to be invoked when there is an impasse between the chambers. Well, both of these allow exceptions, and both of these have been circumvented to a greater or lesser extent by mounted hunts. So it's unsatisfactory, and in Scotland at least, it has been thoroughly reviewed by the government, and there have been proposals for reform, but again, well, this is not Brexit, this is COVID. This has been dropped for the time being from the Scottish Government's agenda. We'll see if it'll come back, hope so. Meanwhile, I mentioned the Law Commission review, but they have said in the report that they specifically excluded reviewing the Hunting Act because it was too politically polarized. So here you can see that issues that are controversial, government doesn't necessarily want to get involved in these issues, and they can certainly take up a great deal of time. Now, I did mention that there's divergence between the administrations, between the administrations as devolution takes hold, and stakeholders in different parts of the country achieve different goals. So I mentioned snaring earlier is a particular interest of mine and something that I've worked on for many years. We have a general prohibition on self-locking snares, but that has been amended in great detail over the last 20 years, Nature Conservation Scotland Act in 2004, and then the Wildlife and Natural Environment Scotland Act in 2011. The end result is that in Scotland we've got very, very detailed regulations on snaring. It is thought, again, we don't know numbers, but it is thought that it's effectively reduced snare use, unfortunately not entirely. Some of these measures are available in codes. Some of them are seen in the Northern Ireland order, which I think it was 2015, but it's more limited. However, I won't delay too long on that because time's moving on. I wanted to flag up, even before the debate I mentioned earlier, I wanted to flag up the protection of seals in Scotland is now very different from what it is in England. England is still governed by the Conservation of Seals Act, which was brought in 1970 following public outrage and concern about seal culling going on in the UK. And what it really does is it prescribes the way that seals may be killed. It sets close seasons, which is very valuable, but it allows exemptions to those for certain purposes, such as protection of fisheries. So it is something that animal advocates had long wanted to see improved. There's a different situation in Northern Ireland because seals have nominally had full protection since 1985 under their legislation that transposed the Berne Convention. However, in Scotland, where we've had a lot of campaigns about seals, we had a Marine Act in 2010, and that contains a section on seal conservation. It makes it an offence to kill, injure, or take a seal, except for purposes of humane killing or under licence. And the licensing purposes are many and varied, including health and safety, prevention of disease, but the two primary uses of licenses are to protect the health and welfare of farmed salmon, so they're used at salmon farms, and to prevent serious damage to fisheries and fish farms. So in other words, fishing and fish farms have been the main users of these licenses. Now, the last one on the list is the bill that is even now passing through the Scottish Parliament. And at a late stage in that bill, the Scottish Government introduced amendments, highly desirable amendments, to remove those two purposes as grounds for licensing. That would mean a full ban on the killing of seals in Scotland. I would like to tell you that this is entirely done on conservation and welfare grounds, and indeed that has been given as one of the reasons. But it's also to protect the trade in farmed fish to the United States, where the US Marine Mammal Protections Act is requiring countries exporting to the States to meet its own standards of marine mammal protection. So if the US fishermen are not allowed to kill marine mammals, which they're not, with certain exceptions, then why should their competitors be allowed that? And so the US authorities are insisting that all foreign fisheries achieve a comparability status. And the clock is ticking on that, and the Scottish Government has accepted it's going to have to effectively end the killing of seals if it wants to protect this market. So that is a good outcome. I couldn't say it's a great success for our advocacy, but we have been calling for it and we are very pleased to see it. We will also be following up and trying to make sure this is really watertight. I mentioned certain other provisions in that legislation. So we've got a lot of complications, we've got a lot of legislation, and we're not entirely satisfied with the protection for the welfare of the individual. What possibilities remain to us? It's been mentioned previously in presentations that there is an Animal Welfare Committee and that others are calling for an Animal Protection Commission. I think that's a great idea, and that it should expressly include the welfare of wild animals. It's currently excluding from the AWC, but it is in the remit of the Scottish Animal Welfare Commission. We've mentioned the Wild Animal Welfare Committee, and that is interfacing with the Scottish Animal Welfare Committee on wildlife matters. So there's good dialogue going there north of the border. I mentioned also the possibility of voluntary codes or voluntary trap approval scheme, and I would refer you perhaps to the article by Sandra Baker that's in the Animal Welfare Journal, talking about how spring breakback traps for small rodents, rats, mice and moles, and the bigger ones could be approved on a voluntary basis. And approval schemes are good ways to market your product as long as they're permitted, but more importantly, that would be why the retailers would presumably become involved in that. But more importantly, it would allow to ensure that these traps, if they're to be used, are effective at producing an instant humane death for the animals they target. I mentioned also the glue traps, and an example of a successful public campaign was the Unstuck campaign, which has persuaded many retailers not to sell these traps. Again, public petitions have been successful there. All of these can contribute to foster political will in government. Approaches, practical approaches, if that was achieved, would be animal welfare impact assessments, which again have been mentioned, and these could invoke 7 ethical principles. I always keep this slide until it's too late to do it full justice. I don't want to detain you any longer because I'm sure there's many questions coming in, but I think if you just look at the headlines there, begin by modifying human practice. Let's think, before we start controlling animals, possibly year on year, let's think about what the human practices, such as grouse moor management, are actually doing to the environment and whether it is sustainable and thus ethical to keep doing that. Evidence must be irrefutable, objectives must be clear, achievable and measurable. Animal welfare must be prioritized in an ethical approach. And I'll skip to number 7 because that comes back to my point about language. If we characterize or even vilify species as pests and vermin, we're not going to make very much progress. I do recommend reading that article. So that is the conclusion of what I wanted to say. I would just like to thank a few people. Thanks to ALAW for inviting me to make the presentation, which I've very much enjoyed thinking about. I'd like to thank everyone in the animal law and the advocacy community for everything you do in this area. I want to thank the Wild Animal Welfare Committee because their members contribute their expertise and their hard work on a purely voluntary basis. And I'd like to thank Alex Simmons for many of the beautiful pictures in the presentation.
Thank you very much, Libby. I love the photo. So cute. Excellent. Thank you very, very much, Libby. I thoroughly enjoyed your presentation. Lots of really great information, as I'm sure I can speak on behalf of all the attendees. So thank you so much for joining us this evening. I know it's been a very busy week for you preparing for the bill as well as the presentation. So we do really appreciate it. Thank you very much. There's some thank yous coming through as well. I don't know if you can see them or not.
Oh, lovely.
As well, just to remind everybody who maybe wasn't in at the beginning when I explained that, next week we won't have our 8th webinar. Advocates for Animals will be hosting a webinar next Wednesday, and the following Wednesday we will resume with our 8th lecture, our last lecture of our series, and we'll actually be hearing from our chairperson, Paula Sparks, and she'll be discussing farmed animal legislation. So again, not next Wednesday, but it will actually be July the 1st at 7 p.m. For our very last lecture. So thank you again so much to Libby and to everybody for attending, and we'll see you in 2 weeks. Thank you.
Thank you.
Thank you, Libby.